In 2012, the implementation of the Legal Aid, Sentencing, and Punishment of Offenders Act, or LASPO, severely restricted the availability of public funds for legal disputes. The baseline rule established by the legislation was stark. The vast majority of private family law cases, including standard divorce proceedings, financial disputes, and private child arrangements, were entirely removed from the scope of public funding. But as this diagram illustrates, the state maintained a narrow, gated channel of exceptions within that disconnected block. If a case involves forced marriage, child abuse, or domestic abuse, the strict LASPO restrictions are lifted, keeping the pathway to legal aid open. However, presenting as a victim of abuse does not automatically release these funds. The applicant must navigate a series of stringent administrative hurdles. To secure legal aid, a family practitioner must build a procedural bridge, connecting the client's urgent statutory rights with the rigid, highly specific regulations enforced by the legal aid agency. Clients seeking domestic abuse injunctions typically arrive in a state of active crisis. Their circumstances are urgent, highly stressful, and administratively disorganized. The practitioner must immediately translate that emotional chaos into the cold, highly structured reality required by the legal aid agency's processing system. This requires executing 3 distinct phases in rapid succession: legally defining the abuse, crossing a strict evidential hurdle, and escalating the funding tier to cover court representation. A failure to comply with the procedural rules at any of these 3 stages will halt the application, leaving the client without formal legal protection, regardless of the immediate danger they face. In the critical first hours of a case, the lawyer is performing procedural triage. They must secure the financial resources necessary to actually fight the legal battle in court. The first step in the workflow is legally classifying the client's experience under current statutory law. This animated wheel visualizes the Domestic Abuse Act 2021. The legislation radically expanded the definition of abuse beyond physical violence. Notice the non-physical categories. Coercive control, threatening behavior, and economic abuse are explicitly recognized as valid legal grounds for protective orders. While operating under separate legislation, forced marriage protection orders are also captured within this broader protective scope for funding purposes. Recognizing psychological and financial coercion in statute allows family courts to address the actual reality of how abuse operates within a household. Yet, this creates a paradox for the practitioner. The Domestic Abuse Act provides a wide protective net in theory, but demonstrating abuse under this broad definition is completely insufficient to release public funds in practice. The true gatekeeper to legal aid funding is the Civil Legal Aid Procedure Regulations 2012. As the wheel morphs into a checklist, we see the legal aid agency's rigid demands. To prove abuse, practitioners must produce specific Schedule I evidence, an arrest record, a protection order, or a health report. Without objective documentation, the application halts. Even with this evidence in hand, there is a common professional misconception on how these are treated financially. In public law, such as when the state applies for an emergency protection order for a child, funding for the parents is automatic and non-means tested. But private domestic abuse cases operate under different rules. The client must still pass the legal aid agency's strict means and merits tests, proving their financial eligibility before the state will pay for their lawyer. The system demands cold, objective documentation and financial qualification. It remains entirely indifferent to the client's subjective state of emergency. Public funding in these cases is not granted as a single lump sum check. It operates as a tiered escalation system. Look at this tiered ladder. The base level is legal help, covering the initial interview, early advice, and time spent gathering strict Schedule I evidence. To secure a non-molestation order, the practitioner must escalate the case to the top tier, legal representation. Here lies a critical flaw. Standard applications for legal representation take time to process. Time is the one resource a victim in danger doesn't have. To solve this, the framework contains an emergency funding bypass mechanism, available only to specific law firms. Firms that carry a Specialist Quality Mark, or SQM, possess devolved powers. This allows the practitioner to self-grant emergency legal aid on the spot, provided they apply for the full certificate as soon as practicable. SQM devolved powers are the only way a practitioner can align the speed of legal protection with the inherently slow bureaucracy of public funding. Once funding is secured, the practitioner still has to navigate standard procedural delays designed to keep normal family law disputes out of the courtroom. Typically, anyone applying for a family court order must first attend a Mediation Information and Assessment Meeting, or MIAM. Domestic abuse serves as a hard statutory exemption to this mandate, allowing the victim to bypass mediation entirely. The legal aid agency also requires a formal warning letter be sent to the opposing party before funding for court representation is approved. In abuse cases, complying with this rule can be dangerous. The practitioner must know when to deliberately ignore it. If the applicant and respondent still live under the same roof, or if receiving a warning letter risks triggering imminent physical harm, the lawyer must bypass the warning step and thoroughly document their justification on the case file. Successfully protecting an abuse victim requires the practitioner to proactively dismantle the justice system's own standard procedural safeguards. This diagram outlines the completed journey from the client's initial presentation to securing an emergency injunction. The successful path requires the lawyer to weave to three distinct and sometimes conflicting statutory systems. Recognizing the client's experience under the Domestic Abuse Act 2021 is only the starting line of the legal rescue. Securing actual safety requires meticulous Schedule I evidence gathering and the strategic deployment of SQM-devolved powers to bypass administrative delays. The modern family lawyer handling abuse cases operates in a dual role. They are an expert legal strategist and a master bureaucratic navigator. Mastering this intricate procedural gateway is the only way to ensure the LASPO carve-out actually protects the vulnerable people it was designed